May I please your lordships? Lordship, I need some accommodation in item number 5. The learned amicus curiae is attending his wife at hospital.
Okay. Mr.
PJ Bora.
PJ Bora, Learned Counsel, appearing for Mr. B. Prasad, Learned amicus curiae for the appellant, has submitted that Mr. Prasad has some medical issues in the family and he is therefore not in a position to attend the court today. He has thus paid for listing of the appeal after the summer vacation. Mr. K. K. Das, Learned Additional Public Prosecutor, or the respondent states who is present, has no objection to the said prayer. The prayer is allowed to list the case after the summer vacation. Appeal.
May I please your lordship, I beg to mention item number 2. Here, my lord, appellant has expired, so it is abated. On 2/8/2023, he has expired.
Mr. N. Hawk, Learned Counsel for the appellant, has submitted that the appellant has expired on
2/8/2023.
2/8/2023. So consequently, the application has become infructuous. In view of such submission made by Mr. Hawk, Learned Counsel, who is to represent the appellant, the application is closed as infructuous. Also, in view of the order passed today in the accompanying interlocutory application, IA civil number 1000/2019, the instant appeal stands accordingly closed as infructuous. Appeal to it.
With regard to item number 4, your lordship, my preparation is not complete. I just need some more time.
On the prayer of Mr.
Aimed.
Yes, the term was 7 years or 8 years. He is already out. What is the period?
7 years, your lordship.
7 years. Detention is 7 and 7. Just take the instruction.
Yes. After application.
Period of detention, imprisonment 7, but
Conviction is for 7 years.
concurrently, no, consecutively, the period is to run consecutively, if I remember correctly. 7 years. Under 4, section 4, FOXO.
My lord.
Then 3 years with fine. Okay.
3 years.
Under section 8. And 1 year under section 12. Oh, consecutively. 7 plus
3 plus
3 plus 1, 11.
11.
That's why it is come up.
Consecutively.
After application, your lordship.
Okay. On the prayer of Mr. A.M. Dr. Learned Counsel for the Learned amicus curiae for the appellant who has expressed personal difficulty, list the appeals after the ensuing summer application and date to be fixed by the office as MS B. Bhuya, then as senior counsel. As not like a full stop error, Mr. B. Bhuya, and as senior counsel in additional public prosecutor who represents the state. Have submitted that state has no objection to the above prayer.
Must.
So should need not have to take instruction from the jail.
No, 11 consecutively. It must be there.
Right.
May it please your lordship. Lordship, I beg to mention item number 3 of the daily list.
Item number
3, my lord.
3.
Yes, my lord. I would like to seek for a short accommodation for today, my lord. As my senior had to leave for Delhi for an urgent matter.
Okay, your name?
Lordship Valentina Villabeno Tanyu, lordship.
लिखिब MS Valentina लिखिलो बनाओ. Learned Counsel has submitted that arguing senior counsel Mr. B.D. Kaur is out of station and has thus prayed for listing of the appeal after the ensuing summer vacation. Ms. Bhuya, B. Bhuya, Learned Senior Counsel, an additional public prosecutor, has submitted that state has no objection to the said prayer poster. Release the appeal. The prayer is allowed, release the appeal after the ensuing summer vacation
Much obliged.
on a date to be fixed by the office.
The release for execution item number 1.
May I please, your lordship? This is a conviction and sentence under section 302 IPC.
You are legal aid counsel?
Yes, I am the legal aid counsel.
Zedas, Hart, Learned Legal Aid Counsel for the appellant, accused appellant, and MS A. Begum, Learned Additional Public Prosecutor for the respondent number 1, State of Assam. Poster. The instant criminal appeal under section 374(2), Code of Criminal Procedure 1973 is directed against a judgment
Page 39, lordship, the order.
dated
Last time.
13/9/2023 and an order on sentence dated
18-9.
18/9/2023 passed by the Court of Learned Sessions Judge Nalbari in Sessions case number 57/2015. By the judgment, an order on sentence, the accused appellant has been convicted for the offense under section 302, Indian Penal Code. And he has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 10,000, in default of payment of fine, to undergo rigorous imprisonment for another 6 months. Full stop. The appeal is admitted for hearing. The case records of Sessions case number 57/2015 we call for. Issue notice returnable in 4 weeks as MS Begum appeared, extra copy. The accused appellant shall take steps for service of notice upon the respondent number 2 by registered post as well as by usual process within 3 working days from today.
Obliged.
Supplementary list item number 11. Meet please, lordship. Yesterday report was called.
Lordship, I have sent the order copy and then one letter also to the superintendent lordship and from police also lordship, jail, superintendent jail, and he has forwarded it to the hospital lordship. I have the copy lordship. He has forwarded, receipt is also there, receipt copy. But till now I have not received lordship.
Expected
So maybe I will try lordship. But now I have not received.
If okay, we'll sit at
One
2.
communication I have received verbally.
We'll sit at 2, otherwise it will roll back to tomorrow.
Oh, that will be better.
We'll sit at 2.
No.
Obliged. On hearing item number 6.
learned amicus curiae for the accused appellant is found absent today on call. MSB Bhuyan, learned senior counsel and additional public prosecutor for the respondent state of Assam is in attendance for the stop in view of non-representation on behalf of the accused appellant, let the appeal be listed after the let the appeal come for answer justice be listed. Please pass over for the day.
Item number 7 and 8.
নাইকিয়া হলে ভটাচাৰ্যক মাতি খালি কাৰণে কেকেটা মিষ্টাৰ দাস কি বোলে
Is 7 and 8 tomorrow. Sir Singh Terra.
My lord, I'm appearing for item number 7, my lord. 8 appearing for 8. Advocate Manu Solani is appearing for 8, my lord. So they are about to start the matter, my lord, but he has not been ready.
You are ready?
I'm not ready, my lord. They say they will start today, Lord Joseph. That's why.
Sir Singh.
Before vacation, my lord.
Then we'll fix the matter. You start.
They are about to start, my lord. On the last occasion, they said they will start, my lord.
My lord, there are about 121 witnesses, my lord. It won't be possible.
It will not be possible then today. Before
Only four are
vacation, not
important.
today,
Only 4 are important, but Lordship would go through the entire.
but we have to go through it.
Yes, ma'am.
Okay.
No, Lordship, can you fix a date, fellow? Then everybody would come, my lord. Only a fix.
No, date fixing is not our job.
Kindly, my lord, because this matter again comes.
We don't know. We'll be sitting or not have we been sitting, we'll be fixing, but we don't want to fix for other things.
Because this matter,
No.
my lord, because there are so many witnesses.
Declined in categorical terms. N. Mahajan for the appellant in criminal appeal number 135/2020. E. Bhuyan, learned senior counsel and additional public prosecutor for the respondent state are present. Post of as sought for by the learned counsel for the appellant. Release the appeal immediately
Well,
after the ensuing summer vacation on a date to be fixed by the office. We don't know whether we are sitting or not,
yes, yes, sir.
right?
I beg my lord.
We do not want to.
No, I
fix.
beg my lord's pardon. I'm highly obliged, Lordship. Obliged.
Is that it? No, আমি নাজানো বেলেগ এটা fix কৰি দিলে ভাল লাগে। Mr. Das, suppose this bench does not survive till 1 o'clock, then we'll post that case tomorrow.
This matter.
If this bench does not survive till 1
Till
o'clock,
1 o'clock. Oh, because only 2 matters left. My
Ah.
friend is doing the matter, I think. Item number 9.
Yes, I can do it, Lordship, no issue.
Kita weakness.
Both weaknesses. 16.
16.
No, why I'm asking her, I don't have the paper.
Oh, you don't have the paper book.
Lost in the offices lost it.
Okay.
I can do it from, if your lordship takes up, then I can do it from LCR.
16 witnesses, you can do it. Okay.
What would it be?
I need to
Mark off
listen
my-
again. Oh, okay. I think I have a good case. I don't know. The accuser's killed his mother. Eyewitness assessment.
Eyewitness as such. no.
It's up to your lordship. If your lordship takes up, I'll see.
Or Lordship, if you want, we can adjourn, no issue, Lordship. If she wants.
No, you're not taking it.
Give me another.
We're hearing.
Later another. I will have to.
Oh, okay. Lordship, the FIR.
Oh.
Yes.
FIR is at page 4, Lordship. I'll read. Humble submission is that in the morning today, that is on 30/8/2017, the ever mentioned accused person engaged in an altercation. I'll give emphasis to this word, Lordship, because my argument will be on
office with my elder sister, Dharmeshwari Khanda, over some domestic matter and caused severe injury in her neck by hacking her with a dowel in their house itself. As a result, my elder sister died on the spot. I therefore pray you to take necessary action against the accused person upon investigating into the matter and obliged. Then, Lordship, the charges were framed, Lordship, under 302, Lordship. And he was sent to the case was sent to the Court of Session Judge Udalguri. PW1 is the brother of the deceased, Lordship. Page 8.
When he was arrested, otherwise,
Otherwise arrested, I didn't get the time to go through the record, Lordship. I came late. He went, in fact, to the police station himself on the day of occurrence. That has come in the evidence, Lordship.
yes.
PW1, Lordship. Page 8. I am the informant of this case. The accused is known to me. He is my nephew. Deceased Dharmeshwari Khanda was my elder sister. My sister was given in marriage at first with one Dilip Chauhan. Out of their wedlock, the accused, who is my nephew, was born about 18-19 years ago. Thereafter, my sister's first husband deserted her, leaving behind my sister as well as the accused. Subsequently, my sister again entered into marriage with one Jiten Khanda about 14 years ago, and the accused, who was begotten by my sister with her first husband, remained with her along with her second husband. Second husband of my sister also died about 5 years ago. Thereafter, both my sister and her son were living together at Bhutia Chang. About 1 year ago, the alleged incident had occurred. At that time, I was at my own residence in Balipara. At the material time, I was informed that the accused had killed my elder sister. So, Lordship, he has just heard. He's a hearsay witness as such.
Lordship, 3817 is the date of arrest.
30,
817. That is,
Okay.
laws on the.
same day.
Was the incident, same day. He went
Morning
to
is
police
the morning
station.
was the incident. In the
He-
morning.
Yes, he went to the police station because in 313 statement, he says that I went to inform the police about the incident. That's what is his explanation. Accused had killed my elder sister. I also came to know that the accused, after committing murder of my sister, surrendered before the Paneri PS. Then I went to the house of my sister and saw the dead body of my sister lying on her bed with deep cut mark on her throat, and blood was oozing out therefrom. While I was in the house of my sister, police from Paneri PS also came there, and the dead body of my sister was taken to hospital. In this regard, I filed an FIR before the OC Paneri PS. Exhibit 1 is the FIR. Exhibit 1 is my signature. Police also conducted inquest on the dead body of my sister in my presence. Exhibit 2 is the inquest report. Exhibit 2-1 is my signature. Cross. My house is at a distance of 25 kilometers from Bhutia Chang, where my sister was staying. At the time of occurrence, I was at Balipara in my own residence. I do not remember the person who informed me over telephone as regards the incident. On the next day morning, after receiving the information in the previous night, I went to the place of occurrence. When police came to my sister's house, I was present there, but the accused was at the police station as he himself surrendered before the police after committing the offense. I put my signature in Exhibit 2 in the police station. I filed the FIR after causing the death of my sister by the accused. The FIR was written as per my version, and thereafter I put my signature thereon. Police did not ask me anything regarding the incident. Then, Lordship, PW2. His Nilamani Deka. The informant is my elder brother. The accused is my nephew. Deceased was my sister. The accused is the son of my deceased sister. The incident occurred 1 year ago. I reside in Balipara, and my sister, along with the accused, were residing at Bhutia Chang at the time of occurrence. At the material point of time, one day in the morning, the informant told me that his sister was murdered by the accused, and therefore I was asked to accompany with him to the Bhutia Chang. Accordingly, I, along with the informant, came to the house of deceased at Bhutia Chang and saw the dead body of my sister lying on the bed with a deep cut mark injury on the throat. In the meantime, police also came to the spot and took the dead body for post-mortem examination. I also went to the Paneri PS with the informant where I saw the accused detained by the police. The neighborhood people of my sister's house told before us that the accused confessed that he killed his mother and thereafter surrendered before the police. In fact, Lordship, 164 statement is there, the confession of the accused. Cross. My sister's house is at a distance of 25 kilometers from our house. I did not find the accused at my sister's house as he had in the meantime surrendered before the Paneri PS. I did not have any conversation with the neighbors of my sister at the place of occurrence. Even in the police station, I did not have any talk with the accused. Police did not ask me anything regarding the incident. PW3 is Dr. Anirudh Bora. He did the post-mortem examination. While I was working as MNHO1 at Udalguri Civil Hospital, I have performed post-mortem upon the dead body of Dharmeshwari Khanda, 43 years, female. The dead body was identified by UBC Raful Ali, Dodhiram Deka, B. Deka, and Pradeep Modak. On examination, I found the following: external appearance. Rigor mortis present, wearing blue blouse and white mekhala, then the carycium and spinal canal, NAD, thorax, larynx and trachea, dislocation of neck, right lateral part. Other organs are intact: abdomen, walls, peritoneum, mouth, pharynx. These are just the description of the parts, Lordship. Injury, next, Lordship, next page. There is a cut mark on the right side of the neck. More detailed description. Deep cut mark present on the neck from right side of the neck. There is a sign of profuse bleeding from the cut injury. Opinion. In my opinion, death is due to shock and hemorrhage. Exhibit 3 is the postmortem report and Exhibit 3.1 is my signature. The injury sustained by the deceased was sufficient to cause death of a person in ordinary course of nature. Cross. I have not mentioned the measurement of the cut mark in my postmortem report. The injury sustained by the deceased was antemortem, but the same has not been mentioned in my postmortem report. PW4, Lordship, Ashok Sharma. I know the accused person present in the dock. I do not know the informant. Deceased was known to me. The occurrence took place about 1 year ago. I reside near the house of the deceased. On the day of occurrence, while I was at my home, police came to me and inquired whether Dharmeshwari Khanda was known to me. I replied that I knew the Dharmeshwari Khanda. Then I went to her house along with the police and saw her dead body lying on her bed with cut mark injury on her throat. Police recovered one Kolam Kotari, Lordship, the weapon, Lordship, but the FIR is about Dao, Lordship. Kolam Kotari, one long dagger-like knife, and the same was seized in my presence by preparing seizure list. Exhibit 4 is the seizure list, wherein Exhibit 4.1 is my signature. Cross. I put my signature on the seizure list in the house of deceased. After showing the long knife by police, I was asked to put my signature in the seizure list. The accused of this case was not present when the police seized the knife. I saw blood stain in the long knife seized by police. I have not seen the seized knife before the court today. That will be white. PW5, Golamunda. I do not know the informant. I know the accused present in the dock. Deceased was known to me. The occurrence took place on 30/8/2017. On that day, I was at my home. At about 6 a.m., I went to the office of the Bhutia Chang TE, where I was a night watchman, Chokidar. After reaching the office at 6:30 a.m., the police officer of Paneri PS talked with our office line in charge, Hitesh Bora of Bhutia Chang TE over phone. After the telephone call, the office line in charge of TE asked me to go to the line quarter number 332 of TE and see there as to what incident had occurred. Accordingly, I went to said quarter and saw the dead body of Dharmeshwari was lying on the bed with cut injury mark on her neck. When I returned to my office and informed the line in charge as to the lying of dead body of Dharmeshwari with cut mark injuries on her neck along with blood-stained Dao lying by her side, when the line in charge came to know about the incident from me, he informed the officer of the Paneri PS in this regard. Again at 8 a.m. in the morning, I went to the place of occurrence, which is situated nearby my house. Before my reaching to the line quarter number 332, police had already arrived there. Police seized the said bloodstained dhow in my presence. Exhibit 4 is the Caesar list, wherein Exhibit 4.2 is my signature. Material Exhibit 1 is the bloodstained dhow, which was seized by police by Caesar list Exhibit 4. After the incident, the accused voluntarily appeared before the Paneri PS. Cross. When I first came to the quarter number 332, except the dead body of Dharmeswari along with Dao by the side of her bed by the side of her in the bed, no one was present. When I subsequently went to the place of occurrence, I saw the VDP secretary of our village along with police. I do not know as to who had inflicted cut mark injury on the dead body of deceased. The line in charge of PE, Hitesh Bora, told before me after commission of the incident, the accused surrendered before the police on the very same day. I have forgotten whether something was written in Exhibit 4, by virtue of which one blood-stained dhow was seized. PW6 Lordship is Jivan Induvar. I do not know the informant. I know the accused present in the dock. The deceased was known to me. The incident occurred on 30/8/2017. At the material time, I was at the tea garden on my duty. At about 8:30 a.m., the line in charge, Hitesh Bora, asked me whether any murder took place in our quarter line. Then I said that I did not know anything in this regard. The line in charge then asked me to inquire that any incident occurred in our line quarter. Accordingly, I, along with Gola Munda, went to our quarter line, and in quarter number 332, we found the dead body of Dharmeswari Khanda was lying on the bed, and on her side there was a bloodstained dhow. I saw cut mark injuries on the neck of the deceased. I also came to know that after commission of murder by the accused of his mother surrendered before Paneri PS, police also came there and seized the bloodstained dhow in my presence and took away the dead body to the PS. Exhibit 4 is the Caesar list of bloodstained dhow. Exhibit 4.3 is my signature. Material Exhibit 1 is the dhow which was seized by Exhibit 4. In cross, he says, I went to the place of occurrence after coming to know about the incident as told by the line in charge, Hitesh Bora. Around 10 persons gathered at the place of occurrence, including the police. Line in charge told me the accused surrendered before the police after commission of the incident. I was not an eyewitness to the incident. PW7 is Lordship Dodhiram Deka. I know the informant, he is my brother. Accused is my nephew. Deceased was my sister. The incident occurred on 30/8/17 on the day of occurrence while I was at my home at around 9 a.m. My brother Binoy Deka received one telephone call from one line chowkidar of Kutiachang TE informing him that some incident had taken place at the house of my sister. Immediately, I, along with my brother Binoy, proceeded to the house of my sister situated at Kutiachang TE. After reaching there, we saw that our sister was lying dead on the bed, and in the meantime, our neighboring people, including police, arrived at my sister's house. I came to know that the accused committed murder of my sister by cutting her neck. We did not find the accused as he voluntarily surrendered before the police after commission of murder of my sister. Police held inquest on the dead body of my sister in my presence, and the dead body was taken for postmortem examination at Udalguri Civil Hospital. In this regard, my brother Binoy lodged the FIR. In cross, he says, police did not record my statement under section 161 CRPC. It takes about 2 to 2.5 hours to reach the place of occurrence from my house in motorcycle. The neighboring people who gathered the place of occurrence told before us that the accused, after committing murder of my sister, surrendered before the police. Initially, the police told me that my sister was killed by the accused. I do not remember the name of the person who told me about killing of my deceased sister. Then Lordship PW8 is Ramu Kurmi. I do not know the informant. I know the accused person present in the dock who is my closed door neighbor. I knew the deceased who was the mother of the accused. The incident occurred on 30/8/17 in the morning. At the time of occurrence, I was at Kutiachang TE for doing work. At around 10:30 a.m., I heard from the other laborers working with me that the accused killed his mother. by inflicting thou blows on her person. On hearing the news, I went to the house of accused along with the chokidar watchman of Bhutiachang TE Golamunda, where we saw the mother of the accused was lying dead on her own bed with deep cut mark injury on the neck. We also came to know that after commission of the crime, the accused Somoto surrendered before the Panari PS. When we reached the place of occurrence, the village people, including police, already gathered there. Later, police took away the dead body from the place of occurrence. In cross, he says, on the day of occurrence, I went for my duty at around 5 a.m. in the morning. Before coming to my work in the Bhutiachang tea, I did not hear any hue and cry at the house of accused. Sometimes the accused stay for the night in some other place. I did not witness the killing of the deceased by the accused. Police did not record my statement. PW9 is Birsa Orang. I know the informant, the uncle of accused. I also know the accused present in the dock. Deceased was the mother of the accused. The incident occurred on 30/8/2017. At the material time at about 10 a.m. in the morning, I was on my duty at the Bhutiachang TE. At the time, the workers of the tea estate informed me that the accused killed his mother by inflicting thou blows on her. On getting that information, I, along with other labor of Bhutiachang TE, went to the place of occurrence and found the along with labor's TE, went to the place of occurrence and found the dead body of the deceased lying on the bed with cut mark injuries on her neck in a pool of blood. In the meantime, police also arrived at the place of occurrence. I also came to know that the accused, after committing the murder of his mother, surrendered before the Paneri PS. Defense. The house is adjacent to the house of deceased. On the day of occurrence, I came out of my home for my work at Bhutiachang TE at about 7:30 a.m. I did not hear hue and cry till my leaving for work in the TE in the house of deceased. I did not find the accused at his house as he surrendered before the police after commission of the offense. PW10 is Philip Tete. I know the informant as well as the accused present in the dock. Deceased was the mother of accused. The occurrence took place about 1.5 years ago. At the material time, one day while performing my duty as a Sandari at Bhutiachang TE at around 6 a.m., I received information from some labor coming for work in the tea garden that someone had committed murder of the mother of the accused at her house. On receipt of the information, I immediately proceeded to the house of the accused and came to know that mother of the accused was lying dead in her bed, but I did not enter into the house out of fear. In the meantime, I also came to know that the accused had surrendered before the police. During my presence, the police also came to the place of occurrence along with BDP secretary, along with people. Thereafter, I returned to my duty, but I came to know that later police brought the accused to the place of occurrence. The deceased was staying with the accused at the time of occurrence. Though the accused had a brother, but at the time he was staying at Chennai for his work. Cross, he says, when I reached the place of occurrence, accused was not available. My house is at a distance of about 250 meters from the place of occurrence. There are other houses near the house of the accused. PW11 is Sanika Kheria. I know the informant as well as the accused present in the dock. The incident occurred about 1 year back. Before the date of incident in the night, the deceased came to my house and told me that she had a quarrel with the accused, and at that time the accused told her that he would cut her into pieces, and therefore the deceased sought my help. Then I told her that it was night, and so I was unable to help her, and also advised the deceased to return to her home. On the next day in the morning, I went for my work at Bhutiachang garden at around 8 a.m. At that time, I heard from other laborers that the accused committed murder of his mother in his house and then surrendered before the police. On getting this informed, I came to the house of deceased. In cross, my house is situated adjacent to the house of deceased. As I am deaf of hearing, as such, I cannot say whether any hue and cry took place in the house of deceased on the previous day. I reside in my house with my father and with my family members. When the deceased came to my house on the previous night, all of my family members were present. On the previous day of the incident in the night, I did not meet the accused. At the time of occurrence, the accused was staying with his mother. I do not know as to who had caused the murder of the deceased. Police did not record my statement. PW 12 is Pradeep Munda. I do not know the informant. I know the accused person present in dock. Deceased was the mother of the accused. The occurrence took place about 1 year ago. On the previous day of the incident at night at around 7:30 p.m., accused came to my home and played Ludo game with me. Thereafter, the accused had his meal along with us. When I felt sleepy, I asked the accused to go to his home at about 9 p.m. Accordingly, accused left for his home, which is situated adjacent to my home. On the next day in the morning, I heard halla in front of the house of the accused at about 8:30 a.m. So I came out of my house and saw a gathering of people in the house of accused. I also proceeded there and saw the dead body of mother of the accused was lying face upward in the bed with deep cut mark injury in her neck and blood was oozing out therefrom. I also came to know the accused after killing his mother surrendered before the police. Police came to the place of occurrence. The dead body was taken to hospital for postmortem. In cross, he says, my house is intervened by another house from the house of accused. On the previous night of the incident, I did not hear any halla in the house of the accused. PW 13 is Probin Chandra Deka. On 38/17, I was posted as second officer at Paneri PS. On that day, at around 6:30 a.m., accused Hiranya Khanda of village Hotiachang TE, line number 13 PS, Paneri, surrendered before the Paneri PS, informing that he had murdered his mother, Dharmasuri Khanda, at their house by cutting her neck by means of a dao machete. He also informed that the dao by means of which he cut the neck of his mother was lying beside the dead body in the bed. On the basis of this information, the OC Paneri PS Sohrab Ali recorded GD number 603 dated 38/17, and I was entrusted with the investigation of the case. As the accused had surrendered before the police, and as such, he was taken into custody and recorded his statement. Thereafter, I proceeded to the place of occurrence along with the accused and recorded the statement of available witness under section 161 CRPC. I drew up one sketch map of the place of occurrence. The blood-stained dao, which was lying in the side of by the side of the dead body, was seized by me in presence of witnesses. Inquest was held on the dead body. Then the dead body was brought to the Paneri PS for post-mortem examination. On the same day, at around 5 p.m., one formal FIR was lodged by Binoy Deka, who was the brother of the deceased. On the basis of the FIR, the OC Paneri PS, Sohrab Ali, registered the Paneri PS case number 68/17 under section 302 IPC and entrusted me for the investigation of the same, as I have already taken up the preliminary investigation of the case by GD entry. I recorded the statement of the first informant under section 161 CRPC, and the accused was produced before the court for recording his confessional statement. I collected the postmortem examination report of deceased. As I retired on superannuation, in the midst of the investigation of case, and as such, I handed over the case diary to the OC Paneri PS for necessary action thereof. Exhibit 5 is the sketch map of the place of occurrence, wherein Exhibit 5(1) is my signature. Exhibit 4 is the Caesar list, wherein Exhibit 4(4) is my signature. In cross, he says, I proceeded to the place of occurrence on the basis of GD entry recorded by OC Paneri. I did not send the blood-stained dao for examination of the serologist at FSL. I did not seize the blood-stained clothes of the deceased. The accused was arrested on 38/17 at 9 p.m. The accused was sent for recording the confessional statement on 38/17 at 11 a.m. I did not record the statement of one Hitesh Bora in connection with this case. It is not a fact that the accused did not surrender before the police after committing murder of his mother, and that I did not send the accused for recording his confessional statement before the court. PW 14 is Sujit Theria. I do not know the informant. I know the accused. I also knew the deceased Dharmasuri Khanda. The incident occurred 2 years ago. On the date of incident in the morning, I went for my duty at Hotiachang TE. At that time, the line Chokidar Gola Munda told before us that the accused, after killing his mother, surrendered before the police. Then I went to the house of accused and saw the dead body of his mother lying on the bed with cut mark injuries on the neck with the pool of blood. Then I returned to my house. In cross, he says, I heard about the incident from line Chokidar Gola Munda. PW 15 is Dr. Ankur Mia. On 1917, I was posted as Additional Chief Judicial Magistrate Udalguri. On that day, learned Chief Judicial Magistrate Udalguri directed me to record the confessional statement of the accused Hiranya Khanda. Accordingly, Hiranya Khanda was produced before me on the same day. After that, the accused was explained that he was not bound to make confession and that if he does so, it may be used as evidence against him. After that, the accused was remanded to judicial custody till 4/9/2017 for reflection. Accordingly, on 7/9/17, Hiranya Khanda was produced by the investigating officer, and he was again explained that he was not bound to make confession and that if he does so, it may be used as evidence against him. However, the accused stated that he wanted to make the confession. Hence, the accused was placed before the supervision of Dinesh Datta, bench assistant, for reflection in the room of steno. On the same day, accused was again asked as to whether he wanted to make confession or not. But the accused stated that he wanted to make the confession, and the accused was explained that he was not bound to make confession and that if he does so, it may be used as evidence against him. After that, as it was found that the accused wanted to make his confession voluntarily, the confession was recorded in my presence and hearing and also read over to the accused, and the accused admitted that the statement is correct. The confession contains a full and true account of the statement made by the accused Hiranya Khanda was in fit state of mind. Exhibit 6 is the confessional statement. 6.1, 6.2, and 6.3 are my signatures. In cross, the accused was first produced before me for recording his confessional statement on 1/9/2017. On being asked, the accused said that he was suffering from ailment. I did not record the confessional statement on 1/9/17, though he was willing to make such confessional statement, and accordingly, accused was directed to produce before me on 4/9/17. Again on 4/9/17, accused was produced before me for recording his confessional statement. I was not bound to provide legal aid at the time of recording statement of the accused. I did not take the signature of accused in any of the pages of the confessional statement recorded by me, right? Exhibit 6. This will have some bearing later on. PW 16 is Sohrab Ali. On 23/18, I was posted as officer in charge of Paneri PS. On that day, I received the case diary of Paneri Police Station, case number 68 of 17 under section 302 IPC to investigate into it. On scrutiny of the case diary, it displayed that the earlier investigation of the case was done by SI Probin Chandra Deka and the charge sheet of the case had remained to be filed. Having found a prima facie case, I laid the charge sheet against the accused Hiranya Khanda, alias Hiren Khanda, under section 302 IPC. Exhibit 7 is the charge sheet, 7.1 is my signature. Lordship, I would like to take Lordship to the confessional statement. That is at page 74. It starts from page 74. Because there are no eyewitnesses, only that the accused went to the police station and his confessional statement.
Yes.
It starts from 74. But the main part, Lordship, will find at page 79, Lordship. Before that, my mother Dharmeswari Deka Khanda had relationship with other person. Therefore, I left my house. On last Tuesday, when I came home, I saw my mother engaging in an illicit act with an unknown person. The person fled from place of occurrence. I quarreled with my mother. Then I stabbed my mother with a dao, causing injury on her neck. As a result, my mother died. Therefore, I have made this confession after realizing my guilt, Lordship. This, Lordship, and now, Lordship, I'll take Lordship to his 313 statement, Lordship. page 30. In certain he tries to give some explanation. Question number 2, Lordship, page 31. The reply to question number 2, Lordship. It is not a fact. I only went to police station to inform the police about the incident. Then again, Lordship, later on, again, with another question, he is saying, question number 15, he says, Lordship, it is not a fact. I'm innocent. I only went to the police station to inform the police about the incident. Then, Lordship, at question number 19, Lordship, at page 37, he says, I'm innocent. Police coerced and tutored me to make a confessional statement. This is what he's saying, Lordship. So, Lordship, basically what comes out, there are no eyewitness, but the accused himself went to the police station. That is what is, yeah. But Lordship, if we take the confessional statement, it's to be taken as a whole. And as per the FIR also, that's why I mentioned about the altercation word, Lordship. There was an altercation.
FIR that PW1,
Huh.
he stayed 25 kilometers distance.
Yes,
He came to the place of occurrence much after all others gathered at the spot. His evidence or his statement in the FIR is on the basis of hearsay.
all
He
the
himself
witnesses,
said.
yes, sir, Lordship. All the witnesses
No,
are
no,
hearsay because they
there
all
are
from
some
the-
post-occurrence witness.
Huh.
There are post-occurrence witnesses. It is a case of circumstantial evidence, right? But this witness, PW1, came much later on.
Much later.
That is what I am saying.
all the brothers.
Other witnesses already visited the PO. He came from some other place when he was informed. All three brothers
They
came
came
to the
later on.
place of occurrence
Later on.
later, much later. In the meantime, the nearby residents paid visits to the place of occurrence.
Hmm.
That is what I am saying. So this FIR contention is to be tested on that basis.
Then Lordship, with that Lordship, confessional statement, his 164 statement, there also he's saying that he had a quarrel with his mother because of something she was doing. If we take-
Quarrel was in the evening or previous night?
No,
In the evening.
with the witness, the one of the
In
witness,
the
Lordship,
evening, the preceding the night.
Huh.
That is what
Huh.
somebody, diseased went to a witness.
PW
PW
11.
11.
Sunday
Then she had a quarrel
and he was
quarrel.
threatening on his-
and threatening. So this is, then it would be premeditation. Rather than cutting, going in your favor, it would be going against you.
But Lordship,
Premeditation, threaten.
Lordship, but then they might have what if we take 164 statement, because otherwise there is no eyewitness, Lordship. If we take 164 statement, we have to take it as a whole. And he is saying that there was a quarrel and that's why he,
Where is anything,
Lordship,
anything feeble at least to support that?
his statement itself, and he went to the police station, Lordship, he surrendered it. He, Lordship, here is a person, what I feel, Lordship, he
How
had
much reflection time was given to you?
4 days, one and
How much?
4 days. 3
In jail, not in police custody.
no, that
See the-
that I'm not
see the
taking.
magistrate, see the
No,
magistrate.
Lordship, I'm not taking that, it was vitiated by the, yeah, I'm trying to use this as a defense for the accused, Lordship. I'm not saying it is vitiated because the magistrate did everything correctly. Lordship, this is one of the,
Reflection time is
confessions.
sufficient,
this is one of the best recording of
more than sufficient.
confessional statement I have seen.
Reflection time he had given, the questions he had put, everything was more than sufficient.
Yes, it is very nicely done. That
So-
I'm not saying.
So your case is at the stage of 313 as a case of retracted confession. But any suggestion during cross-examining all these 16 witnesses?
About, but they are all
No,
hearsay.
I'm
All the
asking, I am
witnesses
putting
are-
the question to you, please answer to it, yes or no?
Uh,
Did you say during the entire trial till the stage of 313, when all these 15, 16 witnesses were examined, put any question or something that at that stage, that my confession was forcefully extracted? No.
No.
You realized at the stage of 313, when
313,
he directly came in contact with the defense counsel.
313, I'm saying because I'm not
Because-
taking it as a plea, lordship, that what he said. I'm just mentioning that he is giving giving his own statement. But then he went to the police station and the dao was found as per how the way he described. But the thing is, lordship, there was a quarrel. That's why the mitigating factor, lordship, will be, I think, quarrel.
No,
So it can be
it
reduced.
cannot be
lordship.
mitigating, it has to come under exception.
That's what, lordship, exception will bring in the exception for lordship of section 300.
The explanation you tried to give in the 164 statement, there should be something more than what you said in 164.
Lordship,
Something more.
these are tea garden people, lordship. What do they know?
At
He has
least-
said as he felt, as he saw, lordship. These are very, I do not know how to describe them. They do not know how to articulately do something,
No,
lordship.
but
That is.
Whether this explanation is believable, that is what we are trying to find out.
Otherwise, lordship, where is the motive? What is the motive? Did the prosecution prove the motive, lordship?
No, but
Motive is absent, lordship.
this PW 11, 12, PW 11, he is not an interested witness.
No, they are neighbors. That I understand, lordship.
So if he found his mother in that condition, then why he was threatening on at an earlier point of time?
No, lordship. Maybe it is
To
a
come
repeat.
under grave,
Maybe it is a repeat incident, lordship. We can,
nothing is there.
that is what, lordship.
Nothing is, we cannot manufacture a story here.
True,
We have to go by this.
True, lordship.
We
That-
cannot manufacture,
True.
though it is possible to manufacture, but we cannot.
Yes, lordship.
We have to go by legal.
That is true, lordship. But then again, I say, since there was a quarrel, so lordship, if it is,
Had it been
lordship, it
something
takes up
more.
exception 4 of section 300, and it can be converted, lordship.
That requires 4 conditions to be fulfilled.
Without meditation in a sudden fight, in the heat of passion, upon a sudden quarrel.
And
And
more,
without
not
the
more than excessive,
and
unfair
without the-
advantage.
yes, undue advantage of the year. Lordship, here is a
All are required to be fulfilled.
one injury, lordship.
That instrument, the position, the force, and the ferocity with which it was struck, those are to be, had it been leg, okay. Had it been hand, but it was neck.
When people are angry, lordship, they do not see leg or
We
head.
don't
or
know whether he was
they
angry or
just
not.
hit it, lordship. That's why I'm submitting, lordship. These are very.
Somebody said, suppose, and that was not a suggestion itself to any of these witnesses, even the neighbors, that yes, whether the lady had some,
I cannot improve on what is not done, lordship, by the council, but what I can submit is what is there in the file. That question is in fact not, and since the 164 statement was already there, that question should have been put, because the thing came, lordship, that the sister was married once and the husband left her, and second time she was married and the husband died 5 years ago. So that part is there.
you say you are married man. You are also a married man.
Yes. That, can it be that meeting?
Grave exception one. Grave. Grave provocation. নানাবতী চাব লাগিব, নানাবতী চাব লাগিব। সেইটো প্লেন। নহয় তাতে নানাবতীটো প্লেন। ওৱানৰ চাব লাগিব। নাই। Absolutely nothing. কি কৈছে তাতে 164ত? এইটোতো আগৰ পৰাই আছিলে না, ৰিলেশ্যনশ্বিপ যদি আছে আগৰ পৰা বুলি কৈছে। If the relationship was pre-existing and the accused had a knowledge, then it would not come within exception 1. If we take this, suppose 164 statement and your explanation there, then he said my so-and-so had a relationship with other person. So it was pre-existing. He had the knowledge. If he had the knowledge, then this exception 1 requires one is grave, the other one is sudden. That would not come within sudden.
Lordship, Ahluwalia.
Provocation would not sudden.
Right now, I do not have Ahluwalia case judgment, Lordship, in that provoke. Lordship, if certain things keep on happening, then that provocation is there at the back of the, and also our.
So as there may be authorities on this aspect.
Army, Air Force. Nanavati.
Nanavati is planned.
Planned, but Lordship, but then provocation, the thing that was
No. If you
in provoked, there
if
is
you read, it is fully planned.
Ahluwalia case.
Taking the arm from the
Yes.
Navy.
And he went and particularly killed
Thereafter,
one
when his
particular
wife
person.
was not there, he went there. Those are fully planned.
But Ahluwalia case, Lordship, there is that wife is, I mean, time and again she is beaten.
So
And Lordship, tomorrow.
Tomorrow we're not.
Okay.
Lordship, there's a finer line between that 164 statement and evidence of PW11. Because Lordship, after the accused person threatened the victim, she came to PW11. Then there was discussion. Then the PW11 asked her to go back home. So there was time for reflection, my lord. It was not sudden. So whether it would come under the exception. my
That is what we are
My lord.
finding. And if it does not fall under exception,
My lord.
then it is first degree.
That is
So
why
that
I'm
is what we
mentioning-
are trying to find
I
out,
know.
whether all this will come.
Under the exception.
That's why I'm
exception.
saying about Aluwalia case, Lordship, in that the husband kept on beating and one day she kills her husband. And the court held that that is also a provocation. Like if repeatedly the person is doing
But
something,
his stand is not consistent also.
My lord.
because of
stand.
313.
E13, he was not saying
That
anything.
is, I think, Lordship, the
Retracted.
counsel speaking through him. That was,
That is what they had done it. If this story would have been followed throughout the trial.
yes, this was in fact.
That is not the case.
Yes,
Not even a suggestion
correct, Lordship.
to any of these 15, 16 witnesses,
But Lordship, for the.
or even to the neighbors through
Correct,
whom he
correct.
he could have extracted something
Yes.
to bring it to
But for
part 1 of 304. That is also not.
But for the councils, because the
No, we
accused
cannot
himself
go.
was, yes. Lordship,
Miss Mazumdar,
accused
for
him-
council fault, don't take this. What is available,
Yes.
you make submission on it.
I'm making
please.
that only, Lordship, that.
Council submission, this, so we are not,
Correct,
we are tied.
correct, Lordship.
You can imagine anything, but so far decision making is concerned, we are tied,
I'll go. by
right?
that,
That is why I am saying.
Aluwalia case, Lordship, that provoked thing. Lordship can fix apart, keep it part-heard or fix any date,
Not
Lordship.
keep
I
part-heard,
don't-
we don't know, because if
Okay.
we keep part-heard,
Okay,
this bench is to be constituted.
Okay.
Then we don't know what is the constitution of the division bench.
Okay.
If we roll over to the after vacation, if this bench is sitting, we can say that immediately after the ensuing summer vacation,
okay,
but we cannot.
fine, Lordship. No issue. ठीक है, sir. तुम्हारे
One minute.
paper book लगे?
We tell.
They do not go for mitigating
No,
factor.
what is the defense to be taken? Had it been taken,
But Lordship,
might have.
before Lordship.
No. Which is not permissible, is not permissible.
That I understand, Lordship.
We cannot look into whatever is there. It is complete bar otherwise, unless the sites brings it. Yes, for the purpose of our satisfaction and conscience, we can look into, but nothing has been brought. Find out whether this.
Yes,
Can you-
Lordship.
can-
I'll bring it.
I don't have any authority at my disposal on the basis of this 164 statement that we can bring it within any of the exceptions. Find out
Aluwali-
any authority.
Aluwalia case, Lordship, she confessed that she had done it and the court ultimately said that that was provocation from time to
Because
time.
this is not the stand
Hmm.
throughout the trial thereafter.
Correct.
Then in 313, you took a complete denial stand. That. And we have to decide on the evidence on record. Not even these neighbors were asked. He could have asked PW 11. What was the reason why
Because
the
motive-
disease disclosed to you that she was threatened? What is the reason your son was threatening you? That could have cleaned the issue.
I am also handicapped,
Could have
Lordship.
cleaned the issue.
I
No,
cannot.
I know.
I mean, I
But
do what is
had
done.
that question been asked,
Yes. Simple.
we have gone
certain-
through 161 statement. Had that question been asked, why
So
your son was threatening you?
that 161 date is there.
We have read it, but we cannot use it.
Let me find something,
Problem is
Lordship,
that-
so that I can, let me find something, if it can be, maybe remand back or something like that.
Remand is not possible. No mistrial.
That
This is not a
true.
case of mistrial.
The confessional statement, the trial itself, I found that it was bhal ke-
তারপর প্রবলেম থেকে তাতে এখন নিলে বলে বলবো। তারপর সানসেট আর লুইস
Okay, try to find out something
Yes.
tomorrow.
Tomorrow, let's see.
What do you say? What is your response?
She wants after the vacation. Her response.
So I was submitting, my lords, he got the time, it was not a grave and sudden provocation. The incident had taken place, my lord. Because in between the lady came to her neighbor and came back. So there was time. It was not like instantaneously that after seeing the incident, immediately he inflicted blow. He threatened her, then she came in between, then again went back maybe, and that the occurrence had taken place. But I have seen in a postmortem report, nothing has been mentioned, the time since date. It's not there.
Learned Trial Court has taken his conduct, post-occurrence
Yes,
conduct
I know.
under section 8
8 of the.
of the Evidence Act.
Yes.
And that is,
That will be
That-
again, Lordship, inculpatory and exculpatory part will be there. So I'll bring those judgments also on inculpatory and what part can be, but then 164
I
statement.
mean, if the things wholly turns out against him, then it goes against him.
That recovery of the weapon of offense from the place of occurrence, and that also lent credence to his version that he had committed the offense.
Huh.
It was
That's
lying
why
nearby.
I'm
near the
not
dead body.
into that. He did not do. I'm not like the counsel who was there. What I am saying is that he did do the crime. But the thing is, since there was a mitigating factor, there was a quarrel and there was something which was happening. And that's why he was provoked to do. That is what the defense I'm taking. Lordship. I'm not saying that he did not do. I'm not into that. Totally not into that.
Injury, nature of injury, the part of the body,
That was
that comes,
vital part.
if it is proved, it is held to be. The question is who had done it. Question is who had done it. Then post-occurrence witness, all these are, most of them are independent witnesses. All the three, leave aside all the three brothers of the deceased. But
No, I'm not
others,
into that.
others are neighbors
Neighbors.
and or all are neutral witnesses. They had deposed what they had seen. So post-occurrence witness 164 statement, the presence of a dao inside, beside the dead body, there is nothing supporting any of the
But
exception.
recovery was not done by his.
When it is there
It was lying
Ah.
there. near the dead body.
to
See for everyone.
for everyone,
To see.
what is recovery?
But that.
Section 27 will not come here. It is lying beside the dead body. Everybody is saying. And nobody, you cannot attribute anything to these witnesses. Say, Gola Munda. Gola Munda, PW 6.
They heard and they came and.
He was the first one.
Heard and.
He was the first one to go there first alone. Then again, second time with
Right.
two of his colleagues. And he has no enmity.
And according to PW 12, my lord, this accused was playing Ludo with them. And at 9 p.m. he left their company.
Tomorrow. Okay, find out something
Yes.
Lordship,
which
after
is
the
directly on the point.
Provocation was there.
Yes.
It was. a
That's why
great
I'm going for
provocation, but,
Ahluwalia case.
But we cannot take it from the record.
Hmm.
It is in the CD.
Hmm.
It is in the CD.
I have
Then,
to find out that whether 161 can be used by, not by me,
You can
not by
try.
prosecution, but by
No,
lordships.
recent 15 days,
In the
till 15
trial
days also you scan the judgment? No.
So that's what lordship. If maybe 30 years back someone passed.
No. That judgment, 100 judgments were referred to, I think, Padiwala, Justice Padiwala. No. Yes. The trial says, trial court can put
Get
it,
the aid.
put something, yes.
That's
Aid-
why I'm
aid
saying,
what is that?
I'm saying
Some
retrial.
active role, some active role.
Lordship, that's
It
why
could have been-
retrial, lordship. If there is,
ধৰিলেও যায় ন চবে ঠিকে পঢ়ি আছে বুলি okay list the appeal tomorrow or after vacation. I'm just going in favor of after vacation.
কালি ঠিক করে নিলে।
Then we'll not keep it partnered.
Lordship, see, it seems, see, I wanted to finish it because I find maybe some reason I won't be saying, but
Research provocation.
provocation to Ahluwalia finish हुआ, Ahluwalia और Ahluwalia ने release किया।
Then we'll not keep it part-heard. If we sit, then we'll treat it as part-heard, but we'll not say. And
It will be,
and
it will be his luck, lordship. I want his luck to work.
secondly, it will be difficult to constitute if this bench is not sitting. It will be very difficult to constitute the bench.
True.
Then if sometimes council makes submissions that some is hard extensively.
It may not be reflected.
This is a difficulty.
Oh.
If this court sits,
Right.
this bench sits after vacation, we'll take.
নহ'লে মই adjournment লৈ ল'ব লাগিব। এইখন
Yeah.
bench আহলে।
Uh,
তোমাৰ কি বন্ধৰ পিছত
I'll make a mention then, if this bench sits, we'll
I'll
just
make it.
observe,
Yes,
then you make a mention,
yes.
we'll remember.
Sure.
Okay, R.D. Mojumdar, learned amicus theory for the appellant, and M.S. Bibri, learned additional senior counsel and additional public prosecutor for the respondent state. List appeal immediately after the ensuing summer vacation on a date to be fixed by the immediately after the ensuing summer vacation.
In order to furnish a copy of the paper book. I don't know.
Okay. MS office to furnish a copy of the paper book to MS Priya. Learn so and so. In the meantime. Doctor.
I'll oblige, Lord.
Youngest council had some personal difficulties, lordship. Matter will be taken after vacation, lordship.
On the prayer, Mr.
I mean, lordship.
I
Amin.
mean, your name is there.
No, lordship.
Appearing on behalf, learned counsel appearing on behalf of Mr. Alhaji
Ji, lordship.
Ayuddin, learned counsel for the appellants. The case stands passed over for the Mr. Kikelas, learned additional public prosecutor for the respondent states. Is in possibility at 2 o'clock.
No, I have.
Item 11.
কি দিছে? এটা কি দিল? এটা তো খালিয়ে দিল। This is not a report from superintendent
Lordship.
Morigaon.
Senior medical and health officer.
I have sent the order copy also, Lordship.
We wanted a report from the superintendent Morigaon Civil Hospital.
In this report, letter, they have stated that.
Because
Little improvement.
it was not with letterhead and all.
My lord.
Because we have
My-
to follow the minimum procedure.
My lord, but this has come from the.
That senior medical and health officer, it is seen that it is addressed to superintendent, right? We wanted a report from the superintendent on an official letterhead. If he vouch for it, that it comes with in WhatsApp also, but if additional public prosecutor vouches for its genuinity, then we'll do it. But the report should come. It is not that physically it should come.
Actually,
And
Lordship,
now there are emails and all. If he vouches for its genuinity, then authenticity, then we'll go for it. It is the same, I think.
No, that's a separate person. The one who had earlier given, his name was
With due
Dr.
respect,
Abdul
I
Jalil.
want to state that patient name so and so. You are not 65, 62?
My lord, 75 actually. I don't-
62?
uh,
62.
75. All my plans stated 75. In fact, my
Now it has
OBC
come 62.
OBC card also says something like that, 75. Sixty, 75.
Improvement.
My lord, in fact, the OPD slip that I had annexed, that also says 74.
Now you are improved. Hmm?
But still, this says still there are chances of unconsciousness.
No, that was previous due to cerebrovascular accident with unconsciousness. Now with little
Now with
improvement
with dizziness and
and
pneumopathy.
neuropathy.
Neuro-
EMC for further investigation.
All my small prayer is if I can be allowed to take the treatment on my own, there's no chance of absconding. My two sons are also in jail because of this, in respect of the same issue. He's a 74-year person.
But we asked for a report from Superintendent Morigaon Civil Hospital.
Lordship.
Get it tomorrow then. Let's try.
Actually, this, as
Keep
I've sent the police lordship to WhatsApp the order copy. So he given the, to the Morigaon Civil Hospital.
The report that I have annexed was from Dr. Abdul Jalil. This page 22 is the original copy. And this is from one Dr. Povitra Kumar Sarkar. In respect of the age, my lord, my 313 statement was recorded in 2022. That says 72 years, that point of time.
Whether this cerebrovascular accident is stroke
Stroke.
or is any medical document to understand? কেতিয়া cerebral কেতিয়া হৈছে এইটো আগতো কৰিছিল cerebral repeat কৰি
My lord.
himself get the prisoner admitted in GMCH. Then the medical board will give the opinion, will take the opinion. And if it is required, we will release. I think. Thank you. I think stroke এটা হয়েছে গতিকে
This is a second
civil
stroke.
hospital Morigaon Civil Hospital superintendent should consider steps for getting himself admitted in GMC because he is 75. Hmm. 75 years when I get 2 years. That was a factor too. আমি মনে করি কনসিডার করি রিলিজ করবো দিব রিলিজ করে দিব
My only submission is, again, later on, he'll have to go back to jail under such circumstances, his age and.
Anyway, he has to go back
My
to
lord, I
jail.
understand, but I understand.
That is the final destination.
I
We
understand.
are
that,
only
But.
we are only trying to consider the
74 years,
facts
my
of
lord.
this case, the age of the applicant,
understand
we
that.
are also considering.
My lord, last year, August, same thing happened. One stroke. This is again within a year.
The reference is so important. Suffering from is related to brain hemorrhage. Tomorrow. নাম কেটা লিখি দিব ডিকে ভরসাইজি কে দাস tomorrow. Scan copy করে বলো Yes, we will call for the scan copy of the case record. This is an application. By this application লিখে দিব 439 NDPS case number 89/2020, arising out of NCB crime number 8/2020. 439, huh? As for consideration of the prayer for bail. MSMS, M. Deka, Learned Counsel, appearing for Mr. Asika, Learned Public Prosecutor, Narcotics Control Board has submitted that the scan copies of the case records of NDPS case number are required to be called for. Let the scan copies of so and so be called for, register judicial. List the case on 26/7 and unknown for the accused petitioner. 26/7. We are calling for case records.